Well, hello everyone. Welcome to our lovely programming today. My name's Tim. I'm going to take you down a rabbit hole. We're going to get lost in the law. Today, we are talking about the Federal Court of Canada issuing a ruling against Justin Trudeau's use of the Canadian Environmental Protection Act ban single-use plastics in Canada. More commonly known, this law banned the use of plastic grocery bags, plastic takeout forks and whatnot, plastic straws. All of those plastic items were covered by this blanket ban. Plastic manufacturers then sued the government, alleging that this order was unreasonable and or unconstitutional. So we're going to have a look at how the federal government derives their power, legislate in this area, and whether or not they overstepped that power. So I'm gonna give
So we're gonna
a
have a
little
look
bit
at
if
how the
anyone's
federal government
filtered in.
derives their power.
Probably plug my headphones in because I can't hear myself. 1 second. Very professional stream. Because I can't hear myself. But 1 second. Very professional stream. That is that's how I listen to the stream to make sure that stream comes okay. You might have noticed I have a new addition to the bookshelf
For myself.
But
1 second. Very professional stream.
that is so this is my annotated version of the criminal code called the Martin's Annual Criminal Code. And you'll notice here I'll grab the this is my pocket criminal code from 2013. Of course, you need this to this is like required reading if you're going to do criminal law courses in law school. Get a look at the thickness of that. And this is the new book. Compare. It's not a fair comparison. So the annotations are actually written by judges, experienced criminal lawyers. I imagine possibly an ex-prosecutor, and they give you a ton of relevant cases and annotations. To put it quickly, annotations help you as a lawyer know what you need to consider when you're going through certain parts of the codes. I just wanted to show that off. It really, this is not a cheap book, as you might imagine. Um, this I've seen this book sitting in the courtroom. So the law clerks for a judge will keep this book handy. That's how good it is. That's how important it is. That's how robust the info inside is. This is the 2024 version, which I think, just like automobiles, I think they go a year ahead. I have a funny feeling come January, this is going to be obsolete. They'll come out the 25 version. But I've got it for now, and yeah, I also paid for the ebook version, right when you're doing research for a law assignment, because then you can just you can control F, you can find yeah, that's the Martin's Annual Criminal Code. I think it retails for like $300. That plus the, like I said, it's not a cheap book at all, but it's probably if this book was worth its weight in gold, I'd be a very wealthy man. So I don't know if I'd quite go that far. It might be worth its weight in, copper wire. But that back up there. So that will replace my pocket criminal code, which was out of date. The pocket criminal code, I bought this in December of 2022. And it is missing a major update to our extreme intoxication defenses. Of course, I opened a book and I opened it at the sexual offenses. But there's been an evolution to our law about using extreme intoxication as a defense to intent crimes, and whether that defense is available to general intent crimes. And so there was some update to the language 2023 in response to a I might have my timeline there. I think the update, there was a court case in 2022, I believe, and then I don't remember when the government passed the legislation updating that section. Might have been late 2023. In any case, that update wasn't in this book. I bought it in December of 20, and I believe it was originally printed in early 2020. They wouldn't have had those updates. And you know what? The law updates every year. There's my 2024 Martins will have Supreme Court cases that came out here or last year. The government has updated the legislation. That book was first printed, and I'll have to buy. I mean, it's I definitely will not buy a new one each year. That's not productive in any way. I believe you can buy updates where the book publisher will go through and they write down like what parts changed, and they'll just send that to you in loose leaf format, like a binder. So you can keep the updates handy, but not have to buy the book again. And they'll just send that to you in loose leaf format, like a binder. So I think my gate's a little high on this. You can keep the updates handy, but not have to buy the book again. I'm hearing
and
myself.
Just send that to you in loose leaf format.
Like I'm hearing myself, and it sounds like I cut out when my voice drops a little bit. Try not to do the vocal fry, but I think my gate might be a little too high on this. So let me, if you'll bear with me for a moment, I will adjust that. Okay, where is... Sorry to hold you up, hold y'all up. I will start the topic in just a moment here. I can't remember. I don't know why I can't remember. Where? Oh, there it is. There it is. There's my noise gate. We're just gonna bump the sensitivity down on that just a little bit. Yeah, that should, okay, let's see if that sounds better now. We're just gonna bump the sensitivity down on that just a little bit. I'm hoping it sounds better. Again, yeah, that's totally professional. Okay, let's see if that sounds better now. I think that made the... We're just gonna bump the sensitivity down on that just a little bit. I'm hoping it sounds better. Again, yeah, that's totally professional. Okay, let's see if that sounds better now. Nope. I think I'm capturing desktop audio. Ah! So I can, again, professional stream. I don't need the desktop audio in the mix. I don't know why I have it. Okay. I think that it has fixed the noise gate issue. I want some noise gate on there. I don't have a lot of background noise in this in my studio, but sometimes a fan will kick in or whatever, and I don't want the mic picking up that sound. Yeah, sounds good. All right, let's get started. We're not going to go through. You can see there's 89 pages here. We're not going through all 89 of them. We're just going to go through the gist of the decision, and we'll have a look at some relevant statutes. So, to give you some background on this, of course, at the start of the show, I talked about how Justin Trudeau had and the Liberal government had brought in legislation to ban single use plastics. They also used an order in council, which is our version of just an order from the EPA. So in the states, sometimes you have these executive organizations that can act outside of Congress through their executive power. The Environmental Protection Agency is one example of such a thing. We have a functionally equivalent system here in Canada where the cabinet ministers can issue an order in council to affect some sort of policy as long as it's within their legislatively delegated power to do so. And that was the topic of this lawsuit. The order in council itself was unreasonable. And furthermore, the order in council, well, there's a complex interaction here because the order in council gave effect to the empowering statute that caused it to exceed the federal government's jurisdiction. So I'm going to explain all of that when we get to that relevant portion. Let's see if I can have a quick look at. Here we go. So this is from the parliamentary website, and it talks about the division of powers in Canada in our Constitution. Of course, division of powers is where our federal government derives its power to legislate on certain matters. And so you can see here the environment actually is not a distinct legislative power in our Constitution. It doesn't say this government has the power to do environmental protection legislation. So, what that gap means is that there is no constitutional requirement that one government or another has to legislate in this area. Both can, as long as they don't step on each other. You get into issues of paramountcy when that interplay when the province enacts a law that is directly in opposition to a federally enacted law. And spoiler alert, typically the federal government prevails. That's just a feature of our the way our constitution was set up and the division of powers was set up. We have what's called cooperative federalism when it comes to our subnational jurisdictions. So the provinces are not subservient by default to the federal government. They're supposed to work together. They have their delegated division of powers, and they're supposed to operate within those powers. When one reaches across and affects the power of another, the courts will rule that ultra vires, or exceeding your authority, your parliamentary authority. It is outside of your jurisdiction. And then, of course, the opposite of that being intra vires is any law that is within your jurisdiction to pass. So they give a few examples here in this. Again, this comes from the parliamentary website for Canada. Um, so it's official government information. Um, so they always have to, in order to figure out the gap of the unenumerated division of power, they have to figure out what exactly the pith and substance of any law is. What does it affect, and how close is it to any other enumerated version, or sorry, enumerated division of power with the Canadian government? They give, again, a couple of examples here. So, seacoast and inland fisheries is a delegated power of the federal government. So, if you pass an environmental matter and its primary function, and again, you go through a pith and substance analysis, and if you determine that the pith and substance of the bill is to impact the government's jurisdiction in the seacoast and inland fisheries, then that becomes a valid use of the federal power to legislate on the environment. Another federal government power is the navigation and shipping. Federal public property, so that is our national parks, along with other federal government property. And they talk about the dominant characteristic and the purpose of the law, right? And that test is the pith and substance analysis. If the law relates to fisheries only incidentally, it may not be in federal jurisdiction. And if you watched my previous video covering the Impact Assessment Act and the related decision on the Greenhouse Gas Pollution Pricing Act, you will recognize this portion where they say you may make laws under the POG power, that's peace, order, and good government. And that, of course, according to the court, global warming causes harm beyond provincial boundaries. So it's a matter of national concern, and the absence of federal legislation will harm Canadians. We're going to get to the R versus Hydro Quebec in a moment, because it is very relevant to this case that we're going through here. But I'm just setting up kind of where all of these terms are going to. You're going to see a few of these terms come in this ruling, so I wanted to make sure that you understood what we're referring to. We're actually dealing with the single-use plastic ban was brought in under the Canadian Environmental Protection Act. Hydro-Quebec was the Supreme Court ruling that established the government's power to make that legislation. And so when the plastic ban caused that legislation to exceed the government's power, it rendered, it was effectively rendering that law ultra vires. Now, severability is a very strong principle here in Canada. If you make a change to a law that keeps its, again, if most of the law is intact and you make only a small change to it, and that change causes it to become unconstitutional, you can roll back. You can undo that change. You can sever the offending principle and have the rest of the law stand as good law. American legal, I guess, fans, LawTube fans will understand the concept of severability if you've watched other legal channels before who have explained it. It's not a very complicated thing to articulate, but just continue to highlight. But yeah, it's not a particularly complicated principle to explain to someone. Severability is just the idea that you can cut out offending portions of laws as long as the I guess the largest portion of the remaining law can still stand on its own. Sometimes you cut out a portion of a law that's so significant to the rest of the law, it can't, the remaining portion cannot stand on its own. Therefore, the whole law is struck down, and so it becomes void and of no effect. It's a misunderstanding that when a court rules against a law, that law just disappears off the books. That's actually not true. The law remains on the book until legislatures repeal it. What happens though is it is null and void, of no effect. So anyways, that was just a quick introduction to the subject matter. We're going to have a look at this decision in the plastics case. So the people who brought this suit was a coalition of plastic manufacturers here in Canada. These are like very large companies in Canada. They employ thousands and thousands of people. So, and then you'll see the respondents. So this was brought as a common law. This was brought as a common law case alleging the excessive jurisdiction. So this isn't a criminal matter. There's no one. No one is appealing a fine or um, a criminal sentence or anything like that. This is this was brought under common law to challenge its constitutionality. And so the respondents, of course, would be this is the ministry in charge of this file. That is the executive branch. I get the Ministry of Health was involved because, and I'll explain why in just a second. And then, of course, the chief lawyer of Canada, the Attorney General. So whenever you sue the country of Canada, you are suing the Attorney General. That is the Canadian legal representative. These are all the interveners. And you're wondering, well, why is a bunch of American companies in here? There actually was some interplay with this legislation and our obligations under NAFTA, I think since updated to the US, Canada, Mexico agreement. But formerly known as NAFTA, the North American Free Trade Agreement. But you'll also see a couple of interveners from the provinces. Again, when you're making jurisdictional arguments, the provinces will have an interest because laws that exceed federal jurisdiction are then, the implication is that they must be provincial jurisdiction. No, I mean, that's not always true. That could be an international thing where the federal government cannot legislate at the international scale. Also, the provinces can't legislate the international. So, it's not always true, but in this case, it would be true that a finding against Canada would have a large implication for the provinces. And so you'll see the provincial interveners here. Not every province intervened. Others were happy just to watch it play out and, basically accept what the court was going to rule. However, the purpose of an intervener is to make submissions and say, tell the court, here are some things that I have an interest in that are related to this case that I want you to keep in mind when you make your decision. You'll see environmental organizations again. Yes, Environmental Defense Canada. Again, they are a huge, so they are a legal fund. They have in-house attorneys that litigate these environmental cases. So you'll see them come up over and over and over again on these large environmental files. Oceana Canada, Animal Justice. And like I said, you're wondering, okay, why is the Ministry of Health involved? Why is Animal Justice involved? And you'll see once we get into the explanation, the overview of this case. So yeah, we've brought an application for judicial review. And so, I guess I should explain. This is taking place in the Federal Court of Canada. The provinces have all of their provincial trial level courts. In Alberta, that's the Court of King's Bench, which is our superior court at the trial level. So they exercise original jurisdiction for civil cases for matters within that province. But who exercises original jurisdiction for federal matters? That isn't limited to any single province. So a province harmed by a federal law can bring a suit in that province and call the federal government as the respondent. But the provinces did not initiate this lawsuit. also because of the involvement of the federal ministries, the best place to have this case, the court that will exercise original jurisdiction over federal ministries, is the Federal Court of Canada. And so I believe this took place in Toronto. I think it said up here it's in Toronto. So the decision was rendered on the 16th of November. Um, this was the judge. So this was again just a judge only, very common in Canada, a judge only hearing. And this is they're not gonna. I don't think they cover the jurisdictional argument here because I believe the parties both consented that this was the proper jurisdiction for this case, and so if that is without controversy, then the court will not address it. Um. Oh, yes. So they're at the federal, and there is a federal court of appeals too. Um. Most times, people deal with the federal court system is again appealing ministry orders. The Minister of Revenue, right? Revenue Canada would be one of those. So whenever you have a tax, you want to appeal a tax order, if you want to bring judicial review for anything related to your tax assessments, that would come to the federal court. There is a specific tax court in Canada. That's actually that was false. But immigration is definitely one that applies to this court. Yeah, I forgot we have a specific tax court in Canada that exercises original jurisdiction over Revenue Canada. Um, but the federal court will handle the other federal ministries, and of the citizenship and immigration ministry is definitely one of them. Um, you'll see First Nations will file their cases in provincial court because First Nations, although their jurisdiction is the federal government, the location of um, the location of the harm that gives rise to your lawsuit occurs within a province, and so it is better. It would be better to hear that case in the province where the harm was suffered. Um, the Assembly of First Nations, the national group that represents Indigenous people across Canada, if they want to bring action against the ministry that handles Indigenous relations, they may possibly file it in federal court. But again, these actions typically originate from a person who was harmed by a law, and then the provincial courts will take jurisdiction based on the location of that person. In this case, there was no harm being fought against. They were asking to review the decision of the entire ministry, which affected all of the country. That's why we're in federal court. There is a federal court of appeal, and that's where this case would go if the government decides to appeal the ruling. Then, of course, that goes up to the Supreme Court of Canada. So let's get into the issue at hand. Where this is a matter dealing with the plastic manufactured items (PMIs). We This law is colloquially known as the single-use plastics ban, but this is the terminology they're going to use for this case. In order to ban the single-use plastics, what the government did is they added it to the list of toxic substances under the Canadian Environmental Protection Act, which is going to be abbreviated SEPA through the rest of this case. So, yeah, there's some complicated procedural history here too. You can see here, once this suit was filed, that part of the law was repealed and reenacted. Um, so it's complicated as to whether this ruling will have an impact on the reenactment, or if they have to bring another lawsuit. Um, typically, again, very, very complicated legal matters here. It is well outside of my knowledge and education. But, anyways, the court found that even though there was an argument for mootness because of this change of the law, the judge rejected that notion, saying that there is still a controversy that exists that the court can rule on and can issue a remedy that will still matter to the parties. So she found that I think it's a she. Sure. Yeah, Madam Justice. So she said that this was not moot and reserved the ability to make a judgment, which was issued on November 16th. Um, the primary applicant is this coalition of the responsible plastics use. Um, yeah, Dow Chemical, Nova, Imperial Oil. These are major major players with this in this area. Um, so this is the Order in Council, and again, that's just our name for a regulatory an Order in Council is an order at the regulatory level, at the administrative level, uh, and these regulations, their legal force exists because of a statute empowering them to do so. The way you would challenge one of these order in councils is challenging the regulation itself because the law stands as good law. You can't attack the law that says we empower the Canadian Environmental Agency to you can't challenge the law that says that we Parliament delegate our authority to this executive power to make regulations in respect of this area. That is absolutely within Parliament's jurisdiction to do. The allegation here is that the Order in Council was unreasonable. So they're saying they're attacking just this specific order and not the law that empowered it to make this order. And so that's very important because your the standard that you would use here rather than an unconstitutional law is simply was the order made unreasonable? Would a person of ordinary intelligence with ordinary knowledge look at the order and determine determine that it is yeah, it's hard to define unreasonable without using the word reasonable. I'm not very good at it. I'm sure there's a lawyer much smarter than me who can make a good definition of how you would find something unreasonable. But yeah, it goes by the reasonable person standard, right? A person of ordinary intelligence, with only the minimum knowledge necessary to understand the issue, would they come to a different conclusion? Um, and that unreasonableness they're alleging is that it was an improper use of the, again, governor and council, administrator and council authority. So these are what order. This is our legal designation for these orders in council, right? The governor and council's authority. Um, and again, that's our executive authority. I actually haven't taken administrative law yet. I have that next semester. That's a nice. It's going to be the textbook for that is about. Oh, my microphone's in the way. Yeah, the book for that's going to be about as big as this one here. My bookshelf is lean, but anyways, distractions aside, let's get back to this. Yeah, so if you issue an order in council and it actually exceeds the authority of the empowering legislation, then that order in council would be unjust, unreasonable. The court can step in and say that that order in council is of no effect. You have to give reasons. You can't just say, well, we think it's unreasonable. You actually have to say, you have to spell out for the court why it's unreasonable. What are the errors that that was made that a person of ordinary intelligence could point to and say, well, yeah, I don't think that's the way that works. And so, and again, if we go back here, they added plastics to the list of toxic substances. And that was how the government derived its power to ban them. Now, some plastics are toxic. I think BPA was that bipoly what, ethylene? No, I'm not sure what the BPA stands for, but yeah, BPA's were found to have toxicity issues. So there are some plastics that are toxic. However, the government just listed them as an entirety. And so the issue that this coalition says is that listing is way too broad. It encompasses far too many things, of which necessarily some may not be toxic. Which would then, so if you list something as a toxic substance, but then there's no scientific evidence that backs up its toxicity, that is unreasonable on its face. Now, you'll see here that the governing legislation, and I'm not going to go through the Environmental Protection Act in its entirety, it's just way too long. It's quite complicated. And like I said, it's not an area I know very well. So I can't speak to a lot of the matters that will come up in that legislation. We'll have a quick peek at it. But just for a relevant section that I wanted to look at. Um, you see here that the legislation says that you can add a single substance or a class of substances. And of course, the government contends that all plastics is considered a class of substances. The reason that the Americans intervened here, they have, here it is, the Canada, United States, Mexico Agreement, CUSMA. I thought it was named something else other than that, but anyways. CUSMA and the Technical Barriers to Trade Agreement, which Canada as a signatory ought to inform the court's interpretation of the substance as toxic under the CEPA. So that's why we had a lot of American interveners, is they're alleging that Canada doing this has implications to their obligations under international treaties. And we have ratified. These are treaties that are ratified in Canada, right? So we have agreed to avail ourselves to the mechanisms that inform these agreements. And so the interveners have standing because they contend that under the treaty we would have a cause of action to bring, a dispute to the dispute resolution mechanism under CUSMA. And of course, the you always presume that Parliament passes good laws, laws that do not offend the Constitution, laws that do not offend our obligations under international treaties to which we have ratified, laws that do not directly contradict other laws. Right? That's always the presumption. And so these interveners are saying use that presumption and say when you pass a law, it is assumed that you are intending to comply with your international treaties. And when laws do not comply with that, then you should use your powers of interpretation to find a way that makes it compatible with our obligations. So I'm not going to go into their arguments again. We're talking about an area of law that well exceeds my education level. Um, and I probably will not be practicing international law of any kind. Um, it's a I'm sure it's an interesting area of law to go into, but um, it's just not something I feel that I can give a lot of helpful information about. Um, the applicants further contend that the decision of the Minister of Environment to deny a request for the Board of Review to assess the alleged risks associated with the plastic. So we have of course, there is a dispute mechanism of the Canadian Environmental Protection Act where people can ask for the Minister of the Environment to consider their request to change their interpretation or to challenge any of these order and councils. Um, the Minister of Environment denied that request, and so they bring this forward to the next level. So a lot of administrative and these executive offices will have these tribunals. There's a tribunal for citizenship and immigration. If you feel that disagree with a decision under those statutory regimes, then you can bring a complaint to the tribunal and ask for them to take a second look at it. If they refuse, you then get the availability to come to the courts and say that the tribunal's refusal to hear my case was unreasonable. That tends to be quite a high bar to meet. The reason that we delegate this stuff to the tribunal is we trust them to make we want to keep these types of cases out of court, and we trust that they are properly informed to make the best decision in the interest that they're protecting. um that's why you have to show, and again, that standard's pretty high. You have to show an inherent unreasonableness with their decision making. um that's that's a generalized rule. There's absolutely much more precise rules that apply to various mechanisms. Right, immigration orders, um, extraditions, you know, anything like that, revoking a citizenship. Those are all very unique circumstances, and they have their own process that would be more enumerated, more precise than the general provisions. But um, for the most part, that's kind of how it works. Um, and then we get into uh, the second argument. So this one's actually a pretty, it's a pretty straightforward argument. You listed plastics as a toxic substance. Sorry, one second. Feel a sneeze coming on. Oh no, it's not gonna go. All right. Well, maybe it'll come back later. Um, where was I? Right. The listing of the plastic as a toxic substance. I made the same flub twice in a row. Toxic substances. Apparently, that's a tough one to get out. But yes, the listing of toxic substances for plastic was unreasonable. It's a pretty simple argument in that to the ordinary person, the idea that every single piece of plastic that's ever been manufactured and will be manufactured is toxic human and animal life or the environment seems to be a stretch on its face, right? So that one's not a difficult one to understand. The second one is definitely much more difficult to understand as it becomes a constitutional issue. They argue that these interveners, the province of Saskatchewan, the province of Alberta, argue that the order is unconstitutional because it falls outside of the federal criminal law power. The leading case on that, the federal criminal law power, is Hydro Quebec, and it deals with the same statute. It deals with SEPA. Now, the federal government has an enumerated power under a constitution to make all laws respecting criminal law. The criminal law power, as it's called, actually goes well beyond the criminal code. And there is a test articulated in Hydro Quebec, and we'll get into that when we get down to that argument, what that test is and how the court applied the test to this set of facts. But I want you to keep in mind that if the Order in Council caused the law to go outside of the federal criminal law power, then that makes it unconstitutional as exceeding its authority. The excessive authority causes that law to go outside of the, and they use the language of guardrails in the Hydro Quebec decision. If you have exceeded the authority of the enabling statute, you're outside those guardrails. You are then also outside of jurisdiction. And as I mentioned before, if you're outside of jurisdiction, then that law is unconstitutional. Yes, the argument from the government of Canada is, hey, we have this power. The power was given to us by statute. We have the power, and we exercised it reasonably. The reason the Ministry of Health is involved is because we're going to what the definition of toxic is. And as you'll find in a court case, that definition didn't matter a whole lot. The threshold for the coalition here was all they had to do was give, they didn't even have to give one example. All they had to do was assert that it was possible for one piece of manufactured plastic to have no toxic effects on the environment or on people. And if I spell it out like that, you would think to yourself, yeah, there's probably one example. I mean, just if you consider every single manufactured piece of plastic that has ever been created and ever will be created, there's one that I would imagine would not rise to the threshold of being toxic. Remember, toxic is it has a legal definition, but like I said, it didn't have to be considered in this case just because the way that the Trudeau government banned all plastics at the same time without actually enumerating this plastic's toxic effect, that plastic's toxic effect. Like, they exist. They're there. But they decided to be lazy about it and just ran the whole thing through as a class of substances. So, the government's argument here is, well, we disagree with their assessments. We think that everything was reasonable, and we don't think we exceeded our criminal law power. So, then there's the environmental interveners. They wanted to pull the POG power in, which was very interesting, because you can still, if you find that something exceeds the criminal law power, then you can still make the argument of the POG power. Think of it as like an umbrella, an upside down umbrella. And if you and then each of the federal government's powers are these little buckets, and drop water into them, right? And you may, if you overflow one of the buckets accidentally, you exceeded your jurisdiction, that umbrella might still catch it and save it. So they made the POG argument. That argument ended up being dealt with quite quickly. Oh, interesting. There is an interesting thing that happens here. So, if you've heard of interveners before, one of the big things about an intervener is you cannot raise new issues. You have to take the case as it was argued by the applicant and the respondent. So they'll issue, right? They'll turn in their there'll be a complainant, right? The applicant. They'll put in their legal argument. Then the respondent will reply with their legal argument. I think there's also a reply from the applicant afterwards where they can kind of rebut the respondent's assertions and evidence. Interveners get to the benefit of seeing those that paperwork and then being able to then make a submission afterward. But one of the key when you're granted intervener status, and you always have to apply for leave of the court, right? You have to ask the court's permission to become an intervener. And you do that by making the argument that my organization or my entity, right? It could be very rarely a person, but usually it's a large organization that advocates for some cause. And you get granted intervener status by saying that, there's an issue in this case that my organization has an interest in. We believe we have something to offer the court when they make their deliberations. Something that we can put in front of the court that says, keep this in mind when you rule on this case. But you have to take the case as you found it. You can't bring in new issues that are not raised by the applicants and the respondents. Sometimes, and yeah, a lot of things have exceptions. This certainly has an exception. You can apply for leave of the court to introduce a new argument, but that is rare. It's rare. It's not something the court will just hand out like candy on Halloween. You have to really compel them to say there's a reason the applicant and the respondent didn't raise these issues, but the issue is so bearing on this case that the court should look at it. So, and then this is the rule. This section 10 here is what the court found. This is what the judge found. The plastic is too the saying, right? Plastic manufactured items. It's too broad to be listed on the list of toxic substances. So that broadness renders the order unreasonable. It also renders the order unconstitutional. So the governor and council acted outside of their authority, which, again, that authority is found in the law, the enabling statute, SEPA. Similarly, the governor and council acted or exceeded the criminal law power, as there is no reasonable apprehension that all listed plastic manufactured items are harmful. That exceeded the guardrails established in Hydro-Quebec for rendering the scheme under SEPA within the criminal law power. So you see that the same issue that made the order unreasonable also made it unconstitutional. By listing an item on the toxic substance list that is not toxic, it's too broad, and it is without controversy that by listing something that is so broad that you have possibly listed something that is not toxic. Right? That's the logic, that's the logical flow to get from A to B, right? You're listing something that is really, really broad under toxic substances. That broad listing necessarily may contain items that are not toxic. Therefore, you are listing an item that is not toxic as a toxic substance. That makes it unreasonable. That also takes it out of the criminal law power realm. We'll go to the test in Hydro-Quebec in just a second, because the idea that, but the central idea I want you to keep in mind is when you enact criminal law power laws, the criminal code, the most perfect example of that, right? It is always to address a harm to society. something that is wrong that the government is attempting to regulate, forbid, address, etc. So by listing, they get the criminal law power through those toxic substances because their harm is uncontroversial. That's why they're toxic substances. Oh, hey, digger. That's a digger with a D. Don't misunderstand that. Good to see you in chat. Hey, I appreciate it. I won't be much longer. This was not supposed to be a very long stream. How long have I been going? Oh my god, I'm already an hour in. Time flies on this stuff. But yeah, shout out to the chat as always. I like to keep it pretty cool around here. I'll interact with the chat all day. I always say that the chat distracts me and makes these streams go on forever, but I love it. I love interacting with the chat. You guys are like, you guys make half the content. Really, you do. Just reacting to the stuff you guys say. Um. Oh boy, yeah. I lost my train of thought. See, this always happens. This is why these go on so long. I lost my train of thought. Yeah, the criminal law power, right? Um. So if your law is not addressing a harm, any type of harm, it's not a criminal law power. And again, by listing an item that is not toxic, it is therefore not harmful, then your law stopped addressing harmful impacts. It is now addressing both harmful and unharmful impacts. That causes it to exceed the criminal law power. That makes the law unconstitutional. All right, we're not, like I said, we're not going through all of this stuff. There's a lot of stuff here in these 89 pages. What I'm going to do is move over to Hydro-Quebec. The facts in Hydro-Quebec is it was the dumping of a toxic substance into the river. Into a river, and there was a consequence for doing so, and Hydro-Quebec filed a suit saying that the government doesn't have the power to make that consequence under SEPA. Yeah, I'm like I said, I don't want to get into this. Was again a very complicated case. I don't want to get into it too deeply. What I do want to do is go through the test that this court case made regarding the criminal law power. This finding here is very relevant, right? PCBs, which is what Hydro-Quebec was accused of dumping into the river, they pose significant risk of serious harm to both animals and humans. That's a very important finding, because you have to establish that the harm exists, that the law is fighting some type of harm. And again, because they found it, there's another argument for POG here, right? But because they found that it fell within the criminal law power, there was no need to consider the POG power, again, as a catch-all. This is the dissent. This was, I think, a 5-4 split. So this was a very, yeah, this was a 5-4 split. I actually haven't read the dissent, so I'm just kind of seeing if there's anything. Okay, so their dissent says that it doesn't prohibit environmental pollution, but simply regulate it. Yeah, and so we will go to the test. See if the test is preamble here. I don't see it. Oh yeah, here we go. This is the test. This is a limited prohibition applicable to a restricted number of substances. The prohibition is enforced by a penal sanction, is undergirded by a valid criminal objective, and so is valid criminal legislation. Specific targeting of toxic substances based on individual assessment avoids resort to unnecessarily broad prohibitions and their impact on the exercise of provincial powers. So the provinces have jurisdiction over waste management and other several other components of environmental law. Oh, sweet! I got someone from Drayton Valley in the chat. Nice, good to see you. You guys get a lot of crazy. Drayton Valley's had a crazy year when it comes. I think you had a major forest fire and a flood, like a big flash flood, happen within a month of each other. Like not enough water and then too much water real quickly. I think you also had a tornado rip through there, or close by. And of course, Drayton Valley. I've driven through Drayton Valley a couple of times, chasing thunderstorms. You guys get really good hailstorms up there. But nice. Yeah, I call Calgary my home. That's it's a great city. I love Calgary. But yeah, once again, getting distracted by chat. I'm hoping not to. I'm only got maybe 20 minutes left content left to go through here, so I don't expect to go much longer. But thanks for dropping in. Appreciate it. Let's go to and so this summarizes the test, and I'm gonna have to. This should be a unique enough word that I should be able. Yeah, this is So yeah, this is the analysis of the criminal law power. I just want to make sure I'm in the correct area, that I'm not reading the dissent by accident. Oh, there's a pith and substance analysis here. I've mentioned that several times. I don't want to go into it on this because this stream isn't about the Hydro-Quebec decision. Oh boy. Going through tons of stuff. All right. Chief Justice. Okay, I'm in the dissent. Okay, so I have to go past that into. I mean, the test is still good. They just applied the test differently. So, if what was it, 30, 35? Yeah, here, okay. So the test is still valid. I'm reading the dissent portion, so we're not going to read too much into how they applied the test, but the test itself is still valid, and that's what I wanted to get into here. Yeah, Parliament is given broad and exclusive power to legislate in relation to criminal law. RGR MacDonald is one of the biggest cases for many, many things in Canada. This comes up all the time. It's in my constitutional textbook. I can't even tell you exactly what that case was about. There was a lot of moving parts in it. Also, RGR MacDonald, I think, is a high leading case on injunctions and applications for interlocutory orders. Want to say, yeah, stays in injunctions. RGR MacDonald has a pretty big, a pretty outsized role when you're trying to apply for those. So huge case. So you know that they're talking about really, really big substantive law in Canada when you pull in RGR MacDonald. And yes, we're in developing a definition of the criminal law, this court has been careful not to freeze the definition in time or confine it to a fixed domain of activity. Right. So criminal law just doesn't just mean killing people. Uh, oh, don't apologize for distracting me. I love it. I love talking with the chat. Um, right. It's not just the things that we say people aren't allowed to do. Criminal law is much broader than that. So the test is here, right? Laws purporting to be upheld under the criminal law power, that's sub 27 of section 91 of the Canadian Constitution, must contain prohibitions backed by penalties. They must be directed at a legitimate public purpose. This is the other the margarine reference is also a major um the major leading case when it comes to uh interpreting our constitution. um the margarine reference is an interesting one. That was, I believe, at the time, a coalition of dairy farmers was seeking to enact. They had lobbied for enactments against the creation of margarine. I'm not a dairy farmer. I'm not qualified to talk about like difference between butter and margarine. The way I understand it, margarine is easier to make, but the dairy lobby was threatened by it, and so they tried to convince they tried to lobby that margarine was harmful and it needed to be regulated, that it was toxic in some way, or you know, I think that was the nexus of um that dispute. And so when the government brought in legislation, they kind of went to the court and they're like, oh, look, we need a court to step in and deal with this because we can't. We don't know what we're doing here. So the margin reference is pretty old. That goes way back. But yeah, this is the definition that the court uses in this case, Hydro Quebec, and of course, this Hydro Quebec decision was cited in the just to make sure that we know where we're coming from, right? This Hydro Quebec decision was a ruling on the Canadian Environmental Protection Act's powers. This decision was cited by the reference or by the judicial review brought in by the plastic use ban. They're citing to this decision here in order to justify the decision that the law exceeded its power, its jurisdiction. So just to remind you how we got here. A crime is an act which the law, with appropriate penal sanctions, forbids. But as prohibitions are not enacted in a vacuum, we can properly look for some evil or injurious or undesirable effect upon the public against which the law is directed. That effect may be in relation to social, economic, or political interests, and the legislature has had in mind to suppress the evil or to safeguard the interest threatened. So when you look at the regulation of toxic substances in the Environmental Protection Act, this makes a lot of sense. We're seeking to regulate and not just regulate, forbid. We're seeking to forbid by some penalty a course of conduct that is harmful to society. And so while the Environmental Protection Act does not make up part of the criminal code, it is still valid criminal law legislation. That's the decision that Hydro Quebec came to. Um, yeah, these two criteria have consistently been applied. Um, yeah, and so this is the portion of the dissent, right? So they laid out the test, but the dissent says, in our view, they fall short of that criteria. And so that's why they dissented. So it does have value to read the dissent of Supreme Court decisions. They often articulate a very good test, and they'll do a very in-depth analysis on the test, and that that analysis can often be very helpful when you go to make an argument down the road. Um, you just have to always be careful when you're citing a dissent, because that is not their conclusion is not good law. Um, the dissent was the minority decision of a Supreme Court, so that means that they lost. Their decision is not what stood. So you do have to be careful when you cite the dissent. You have to make sure that you're going towards their analysis, their the articulation of tests, legal tests. Because if you cite to their conclusion, it got, it wasn't of force and effect, and so I'm not saying there's no situation where citing to the conclusion is helpful, but as a law student, if you cite the dissent, you better really know what you're doing, because that'll get you a repudiation from the law professor if you make that. And people have made that mistake. I made that mistake just now. I wasn't sure if I was in the dissent or the majority decision portion. If I had not taken that care and caution, I might have just read something off and been like, "Oh yeah, that's our law now." No, it's not. I see that Morgentaler here is mentioned. I believe that was what legalized abortion in Canada. Morgentaler. Or I guess legalized is probably not the correct term. It struck down the law that forbid it. It didn't technically, it um, made it not illegal, which is not the same as making something legal. I guess. Yeah, actually, for the most part, things that are not illegal are legal. Anyways, that's all I had for Hydro Quebec. I just wanted to go through the criminal law test. Um, and so central to the criminal law power is that you're fighting a harm. There has to be some sort of articulable harm that you're fighting against. And now you start to see why the court ruled the way it did when you introduced a overly broad category of plastic, all plastic, of which it necessarily contains at least one item that does not fall under the definition of a toxic substance, a substance that is harmful. You are now seeking to forbid, and you're seeking to forbid something that is not harmful. And when you use a law to forbid something that is not harmful, that is no longer criminal law power. The Environmental Protection Act derives its force, its constitutionality, from the criminal law power. So once you have exceeded that guardrail, you have made the law unconstitutional. Now, if I go back to this, I think the court did quickly look at the POG power. Costs POG. Nope. 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 Sorry, I'm not gonna look for very long. If I can't find it, I can't find it. That's fine. But anyways, the POG power, which I covered much more extensively in my impact assessment video, but the POG power is the peace, order, and good government. That is the national concern. There are other POG powers. Emergencies fall under POG power, but they are temporary in nature, and so when you're seeking to deal with laws that are permanently enacted, you're going to typically fall under that national concern branch. That's Crown Zeller Bach, Crown Zeller Bach. Again, that case is also in my constitutional law textbook. There's a very complex test under that national concern branch. Oh, here we go. I found it. There it is. Crown Zellerback. I agree that the national concern doctrine is not a justiciable issue in this case. Now, this is the important part. The judge did not go through. The judge is not making a ruling on this matter. Um. Oh. Um. Okay. Oh, okay. Interesting. I did make a mistake. The interveners of Saskatchewan and Alberta were required to file their factums before the respondents, but after the applicant. So again, when I said interveners can't bring new issues in, what happened was that Saskatchewan and Alberta put their factums in before the respondents did, and so they were proactively saying, if they bring this up as an issue, we disagree that that is the proper reading of the law. They were being proactive in that case. um, and of course, environmental justice and environmental defense. They say, well, Alberta and Saskatchewan put the issue in, so now we're allowed to argue for it. And the judge is saying, well, no, that's not how that works. Um, First of all, by proactively saying that we disagree that this power is at issue, that's not putting it in issue. By arguing against its application. And so, yeah, you can hardly say that they raised it as an issue, saying, again, it's, you know, it's not a contradiction to say, we don't think this applies. And then you can say, well, they said it doesn't apply. I want to argue that it applies. Like, well, no. They didn't open the door to that. You need to, the respondent has to put that in issue. And they could have, right? They Saskatchewan, Alberta put their factum-ins before the government of Canada. So the government of Canada could have written in their factum and said, we want to put this matter in issue before the court. Then the interveners can come in and say, this issue was put, this was put into issue by the respondent, and we feel that we can speak to this issue. So it's not a contradiction. It doesn't defy common sense. I think the court here is exercising some good common sense. Hey, it wasn't put in by the respondents, and it wasn't put in by the applicants. So we're not gonna, we're not gonna deal with it. But she does give this little sidebar here, or I guess it's not a sidebar. It's just she adds an additional thing saying, not with the benefit of having a proper and full legal analysis, but just saying kind of on its face at the top level of consideration, a constitutional challenge using the peace, order, and good government clause would not apply to a class of plastics because they don't have that singleness, distinctiveness, and indivisibility that clearly distinguishes it from matters of provincial concern. When you're trying to, the reason this worked on the greenhouse gas, again, you'll recognize this argument from the greenhouse gas case. The reason it worked there was because it was carbon dioxide pollution. That was the one issue. It was a single issue. It was distinctive. It was indivisible. There are different types of carbon dioxide emissions. Well, actually, that's no, like carbon dioxide is a chemical makeup, right? If you emit something that's not carbon dioxide, then it's not, yeah. If you emit some other carbon emission that has a different chemical makeup, then it's not carbon dioxide anymore. And so that's why that argument worked in that case. And the judge thinks that because this class of plastics is so broad, encompasses so many different items, there is no singleness, there's no distinctiveness. And this is not an indivisible issue. It's actually very divisible by each individual plastic. And of course, some of those plastics will be of matters of provincial concern, right? Recyclable plastics, which of course falls under the waste management branch, and that is a provincial jurisdiction matter. And so, and again, this has no legal. This statement here has no legal effect because the court hasn't properly considered. It's not ruling that this issue would be a not a good application of the POG test. Um, it's not making that ruling. It's simply making a note and establishing it. So again, it's not a law that I can. It's not a case I can cite that says this is why you have to follow this logic. It's not a ruling, and it wasn't properly considered on it the full availability of the evidence. The judge is making sort of a comment, an offhand comment, saying, at its face, I think that this is what it would be. And so it has some weight. It would have some weight if you wanted to go and cite it. You'd want more though. You'd want a more substantive. You'd actually want a ruling with evidence, and we may get there. We may get there with future litigation of this issue. The federal government, for its part, has said they're going to appeal. What am I at? An hour and 20 minutes. I'm going to wrap up here. Yeah, again, citing Crown Zellerbach. This Crown Zellerbach is the leading authority when it comes to the peace order, good government powers. So, when we're dealing with that issue, we see it come up quite a bit. Oh, and she also makes this other note here. One of the defining characteristics of that test in Crown Zellerbach is that you have to assert that the provincial inability to act is harmful to the Canadian public as a whole. And there's no evidence that the provinces are not prepared to deal with plastic pollution. Most provinces have plastic recycling. They have laws in place regarding littering, the improper disposal of plastics, and so on and so forth. So it's not like there's any provincial inability to regulate in this regard. No. Double doctrine, the double aspect doctrine. Again, when you're dealing, because the environment is not an enumerated, so therefore federal and provincial, they both legislate on the same issue as long as they're within their own jurisdiction that can be traced back to their other like enumerated division of power. Um, However, they argue that by allowing the federal government, this may trigger the federal paramountcy principle. That's what I talked about earlier, where federal law can supersede provincial law if there ever is a dispute between the two. The presumption is that the federal law wins as long as they're both constitutional. That is the thing too. A law can validly regulate the same thing at both the provincial and federal level. It can also invalidly regulate something. That makes it unconstitutional. That wouldn't trigger paramountcy. It would simply just say this law is of no effect. Um Anyways, what else did I want to show? This is the Canadian Environmental Protection Act. Thank you, Canley, for this. This is the only section I thought was relevant that I could go through. Where the ministers have assessed, this is Section 84. Any information under Section 83 and they suspect that a substance is toxic or capable of becoming toxic, the minister may, before the expiry of the period for assessing information, permit any manufacturer and permit any person to manufacture, import, subject to conditions, prohibit, or request any person to provide additional information. These are the regulations, right? Permit, prohibit, request additional info. This is backed by penalty. If you violate these, then there are I don't know where the penalties are listed, but I didn't want to go through this act too much. It's a fairly large act. But that's going to wrap up this presentation today. I hope you guys enjoyed that, as usual. I'd appreciate the like. I appreciate if you share this. Um, I'm on the road. A shout out to Legal Vices that had me on yesterday for his F It Friday stream. And then I hopped on over to Aussie Overlord or Overlord, is the way you say that, I think. So I'm thankful to both gentlemen for having me as a part of their streams. I'm, new, up and coming. I'm still a law student, so I don't practice law. I hope to practice in the criminal defense realm someday, but we're not there yet. I'm still in law school, but you learn a lot of these cases, and I think they have value in teaching people. There's value in teaching people how our law works. It makes you a more informed citizen. It helps you argue things that perhaps when it comes to the like what I said before, it defies logic and reason that the Trudeau government would list every single plastic in existence as a toxic substance. That defies logic. But why is that bad law? You can't simply say, well, it just doesn't make any sense. It's not logical. Well, no, you have to come up with a legal argument. And so, through these videos, I hope I can better inform people on how to make proper arguments when they're arguing against public policy. You'll find I get very political on this channel. If political blood sport is your thing, I hope you stick around because I do tons of political videos. You'll find in my library, in my catalog, I've done commentary on political issues. I've done several on the Trudeau's climate agenda. Um, I've done I've covered political debates. I do live streams during elections. Um, we have the upcoming elections. There's not going to be any more this year than I know of. Next year, British Columbia has their provincial election. Saskatchewan has their provincial election, and of course, you have the American presidential election. And I have guessed it on Nick Rekieta's show during presidential elections. I appeared for part 1 and 2 of the 2020 presidential election. I appeared last year for the midterm election as a guest on Rekieta's stream. Um, these are topics that I love talking about and I'm very passionate about. Um, like I said to Legal Vices, I've been a political operative for over a decade now. Um, I I don't like the spirit of the political debate so much. I will debate. I'll talk about anything to anyone. I don't mind it. I just don't think there's a lot of value in it. I'd agree with Legal Vices on that there's not a lot of value in the debate. Um that said, it's something that I care a lot about. So if someone will come in and challenge my political beliefs or political assertions, then we'll have a conversation about it. It will always remain just as a conversation and not much more than that. So I'm not interested in yelling, shouting, or starting a drama channel. We get enough of that. We get enough drama on Nick Rekieta. We don't need any more over here. But when I talk about the influences, the people that I look up to in the LawTube space, Nick Rekieta is the one who put me on the internet for the first time to a large audience. I'll always be thankful to him for that. Of course, Nick Rekieta is how I met Drexel. So people who know me from Drexel's show will, um, ever thankful to Drexel for trusting me with his media empire, if we can call it that. Um, of course, Jeff and I have Legal Vices have always got along well, and I thank him for including me in things. He I'm a channel with 320 subscribers. There's no reason that he needs to include me in anything. It's not of any benefit to him at all. I'm not bringing a new audience to him. But he chooses to do so anyways, and so for that I respect him immensely, and I'm very thankful for that. Same with Aussie Overlord, right? He doesn't know of me very well. He's never heard my legal opinions. Not that I have valuable legal opinions to begin with. Not being a practicing attorney, not still being in law school, still learning. But he didn't. There wasn't a lot of benefit in having me on his show, um, and he chose to do so anyways. So again, shout out to Aussie Overlord. Um, I've of course Ian Runkle has done a collaboration on my channel. You'll find that in my catalog. It was we were talking about Canada's firearm prohibitions. We went off the rails. We talked about everything under the sun with Mr. Uncle and Runkle of the Bailey on YouTube. So very thankful to Ian again. Right, we're talking about someone with a large reach, a well-established channel, and he comes over to my little neck of the woods and says, and he shared my video out on YouTube or on Twitter, so I got a very big boost in viewership from that. So very thankful to Ian for that for me. Um, one of these days, I'm going to reach out to Viva Fry, see if he'll come on my channel. I've interacted with Viva just kind of as a super chatter before. I don't know if he really, not sure he'll recall or remember who I am. I remember having one in-person interaction with him on one of Ricada's streams. I think it was during the election. And the memorable moment from that is I know how to speak of, a tiny amount of French. And so I spoke a little bit of French to ask Viva how his day was going, right? Comment ça va? Or in Quebec, they just say, or at least in the area of Quebec that I've traveled through, it's common for them to just go, ça va bien? And so he responded in French, and that really annoyed that annoyed Ricada, because, of course, he doesn't know French, and, he does his thing where he's like, okay, we'll get these French Canadians out of here. So, but yeah, Viva's someone I'd love to have on this channel sometime. We could Viva is, like me, he is politically active. He is a political operative. He has run in an election before. I have not, but I have worked for many politicians, and I think we would come from a similar enough background that we could have a very good conversation about issues in Canada. I know the majority and the bulk of his topics are American. I think he's permanently relocated to the States now, possibly Florida. But I'm sure there's still room in his heart for a good old fashioned Canadian political debate. Um, we may very possibly be looking at a Canadian federal election next year. The supply and confidence agreement that the third party has with the minority liberal government here, and if you saw me on Aussie Overlord, we talked quite a bit about minority governments, kind of multi-party parliamentary systems. It's very different from how the U.S. elections work, and that difference gives rise to some issues that perhaps American people are just not familiar with, things that can happen. And one of those side effects is that a government can fall before their 4-year mandate is up. And that's the situation we're in with the Trudeau government right now. He's in a minority government. As long as he keeps that third party coalition that he's created with the Democrat Party, as long as he keeps them happy, they can go their full 4 years. But there's been some cracks. There's been some controversies in that agreement. And I'm thinking that the New Democrat Party may be looking to pull the plug on Trudeau's minority government in order to obtain a better electoral result, right? Win more seats, get more power in our parliament. Because as it stands now, the NDP is not the only party that agrees with the Liberals that can keep their legislation in play. We saw when the NDP actually crossed over to the Conservatives to support the... Sorry. That's my sign. I gotta wrap up soon there. I'm getting a dry throat. We saw with the heating oil controversy that the NDP actually joined the Conservatives in trying to pass a motion. The Bloc Québécois opposed it with the Liberals, and that was enough to defeat the bill. So the NDP would be looking to be the only party that can hold up the Liberals, and that way they have much more flexible, much more power that they can flex over the Liberal Party to get their agenda passed. So anyways, I think that's going to wrap it. We're at an hour and 34 minutes. That's about as long as I wanted to go. Maybe a little bit longer than I expected. But like I said, I hope you guys enjoyed this. Let me know. Leave some comments. Know what you're thinking. Like I said, I love interacting with people who watch this channel. I'm always thankful and ever, you know, your ever generosity for watching me come on the internet and just talk about boring law nerd stuff. I'm always thankful for that. Um, if you do want to support this content, I forgot to put it in the description. I'll edit it after, but or I could put it in a chat here. But if you do want to support the content, I have a manual donation that you can do through my third party provider. In Canada, it's kind of like the equivalent of Moneris or Interact or whatever. It's called Stripe, but um, I have a third party credit card processing provider. That because this channel is not monetized on YouTube, so I can't take super chats yet. We're on the road to get there, though. We'll get there. But I do have my own personal website. I don't store credit card info on it. It's processed by a third-party provider that is, an industry leader in encryption and credit card processing. They're used on lots of websites, thousands, I'd say. But it's lostinlaw.ca. It's the same as the channel name. /donate. You go visit that. Go visit that link. You can. Oh, hang on. It's not donate. It's not /donate. It's donations. I believe. lostinlaw.ca/donation. Yeah, I don't even know the link to my own website. That's how unprofessional of me. I apologize, but yeah, if you visit that link, you can drop me a one-time donation. It's kind of like it's a non-copyright infringing non-trademark infringing ability to chat at the super level. But yeah, like I said, I don't store any financial info. I do store your name and the comment that you leave behind. But other than that, the credit card info is processed by the third party, so I don't deal with it. If you feel so inclined, if this is content that you think you'd like to support, I appreciate any and all amounts and any consideration thereof. Thank you very much, and guys, have a good day. Stay frosty, everyone.